Hello, and welcome to Justice Speaks. I am Judge Brian McKenzie, a retired judge from Michigan in the United States. Justice Speaks is continuing its series of interviews regarding individuals who are impacting the justice system, interviewing justice leaders to get their perspective on the current state of the justice system and where they think it should be going. Some of these leaders you may know or have heard of, and some you haven't. All of them, whether educators, practitioners, or observers of the justice system, will give you as listeners a better understanding of how the justice system works and where it is going. Or in this case, the justice system of the country of Japan. To give us his perspective of the legal system here in Japan, I am delighted to introduce Dr. Yasuhiro Maruyama, a professor of criminal justice at Rissho University here in Japan. Doctor, welcome to Justice
Yeah,
Speaks.
thank you so much for inviting me. Yeah.
It's a delight to have you on Justice Speaks. I'd like to start by asking you to tell me about yourself.
Yes, thank you. Hello everyone. I am Yasuhiro Maruyama, not marijuana. I'm a legalized one, I hope, in Japan. So I'm a professor of criminology and criminal justice at the Rissho University in Tokyo. My main areas of focus are drug policy, human rights in prisons, and death penalty. My research explores bipolarization of Japanese punishment. By this, I mean that Japan's criminal justice system combines harsh punishment with care for vulnerable groups, while we have recently introduced some new treatments for vulnerable individuals in the system. There are still many issues that need to be arrested, such as the death penalty and life sentences. Unfortunately, support for juveniles, the elderly, drug users, and people with developmental disorders is still lacking. In Japan, judges often give severe punishments, such as the death penalty or life imprisonment, to offenders with tragic pasts, not just adults, but juveniles as well. And can I talk about my memory about drug court?
Yes.
Okay. So I first learned about drug courts when I was 20 as an undergrad student. At the time, I was working on a project about solving problems of people who use drugs and presented a report at the university. There were only one or two papers available in Japan on drug courts, and I introduced the topic in my class. But fortunately or unfortunately, one of the practitioners who support self-help groups in Tokyo in the class and challenged me, asking how I could fully understand the US system based on just one or two papers. You know, I never expected someone to question a just 20-year-old student like that. So normally I would have felt depressed, but at the moment I knew I had to go to the USA to see drug courts in action for myself. So I went straight to the USA to do research. My English wasn't great, but I jumped right in. That's when I first met Judge Peggy Hora, whom I considered my American mother. And Peggy truly supported me like I was her Japanese son. So some people actually believed she had a really Japanese son because she had been to Tokyo and Kyoto before. It was so funny story than that, right? So, but I was shocked, so shocked when I heard the news that Peggy has gone, and I miss her. I so want to meet her right now. I genuinely pray for her happiness in the next world. since then, I have been studying drug courts and problem-solving courts starting from 2002 or 2003. And in 2005, I met Judge Jeffrey Rochnick. You know,
Yes.
he was a second judge at the Miami-Dade County Drug Court.
He is a friend of mine.
Yeah, okay. So he has helped me as like my American dad too. I am so lucky, because great judges support me. Yeah.
Well, let's talk a little about that.
Yeah.
You said you specialize in what type of criminology? What are your areas as a professor?
Uh, I, you know, um, I am, I was a member of UC Berkeley, that.
Yes.
So I like um, critical criminologies and, radical criminology. So what is a problem or what is a crime? So the majorities control the minority by using the crime.
Mm-hmm.
So what is a crime? The majority likes this action. It's not crime, but the majority doesn't like this action. It's a crime. So
Okay.
yeah, this is very interesting.
That's a very interesting idea.
Yeah.
Okay. You were a visiting researcher at ICPR at the University of London. Is that correct?
Yes. Correct.
And also, you were a visiting scholar, as you mentioned, at UC Berkeley School of Law.
Yeah.
Can you tell us about those experiences?
Yes. So you know me well, thanks. I was at the University of London in 2017, and then at UC Berkeley from 2018 to 2020. During my time there, I attended law school classes in criminology and penology, and I studied under scholars like Malcolm Feely, Tony Platt, Franklin Zimmerlin, and Jonathan Simon in UC Berkeley. I also had the opportunity to present at the conferences and meetings with them. While in California, I visited numerous prisons with the support of Peggy. I spent 2 years as an observer at both the drug court and mental health court in Oakland. And additionally, I had a special opportunity to train and conduct research for 2 months at the DUI court in Sonoma County, which I learned is one of only 2 DUI courts in California. I heard.
Really?
Yeah, very few. Yes.
Go ahead.
Go ahead with others. And I am so minorities in Japan, I guess, but the people who I met there, all researchers and practitioners agree with me. So I'm so confusing. I am majority in this country.
Ah, I see. Let me talk. I want to say to the listeners of this podcast,
Yeah.
the professor has mentioned Judge Peggy Hora, who was an original founding member of the Justice Speakers Institute and a regular presenter on our podcast, Justice Speak. She passed during the time of COVID. And so when the professor talks about his relationship with her, it's how I met him and at a drug court conference.
Yes.
And she was always open to the potential of learning something new from people who brought a unique perspective. It's part of why we're here interviewing the professor, but it's only a part because he brings a very unique and interesting perspective to the whole area of criminal justice. So I'm going to now turn back to you, Professor, and ask you to tell us about the Japanese criminal justice system. Can you describe it for our listeners?
It's in Japan, serious cases are handled through the Japanese rate judge system, while misdemeanor crimes are tried by professional judges alone. Although Japan still has the death penalty, the number of executions has been decreasing in recent years. An issue currently gaining attention in criminology is the increasing number of elderly people and the individuals with intellectual disabilities who repeatedly return to prison. To address these initiatives like placing social workers in prisons and establishing specialized community facilities to provide support have been introduced. However, Japan does not have problem-solving courts like those in the United States. This raises the question of how to address issues that cannot be effectively solved by the traditional criminal justice system.
Okay. So, no jury trials.
Uh, Not jury trials. The lay judge system is, in US and UK, the jury system is just decided to guilty or not guilty.
Right.
But our system is not only this decided, but also the how many years in prison or the probation systems or
Okay.
the sentences in
But it's also the model that the Japanese courts work off of was originally designed after World War II, and it has some basis deep within it of the American system.
Good points. I don't know why. We had a jury system before the World War II, and unofficially the Japanese government just stopped the jury system, not abolished, just stop. But we can choose the restart that jury system again. But you know the government and the professionals that make new systems for the lay judge system.
Okay.
Similar by European style.
Okay.
The Germany or French.
Right. So let's talk about the differences with the American criminal justice system. What are they?
I would like to talk about two topics
Okay.
in this topic. So one of them is what stand out to me is that many people active in courts aren't limited to legal professionals like judges, prosecutors, or defense lawyers. These individuals, despite not being part of the traditional legal professions, are also highly respected. What I notice is that in Japan, both judges and university professors, except me, seem to have caught a disease where they feel they cannot admit when they don't know something. So they act like they understand everything, even if they are not experts in that area. But I have the good experiences in NADCP conference. One key lesson I learned from attending the NADCP annual conference that I joined one great session with good drug court team from Santa Barbara, maybe I think, is the importance of acknowledging when you are not an expert in something. The professionals there are excellent at making use of each other's expertise and are quick to wave the white flag when they lack knowledge about the problem.
Okay.
And the another topic is in this session. This topic that another major difference I've observed is that Japan does not use imprisonment to address potential future dangers, unlike the USA and some other countries. in Japan, so very confusing the explaining that in Japan, prison is strictly limited to actions that have already occurred. Imprisonment is only given for responsibility over past behavior.
Okay.
And it is prohibited to imprison someone for something that might happen in the future. This principle stems from lessons learned during World War II, because punishment was widely used to suppress dissent, with citizens punished even before they commit the crime if they were perceived as a threat to the state. So what is considered the dangerous can often depend on the majority's opinion,
Right.
which can easily shift, right? So we have since moved away from that, and punishment is now only applied after a crime has been committed. So, however, we don't apply the same principle to drug users who are imprisoned and coercively treated for their addiction, almost as form of punishment. But almost all of Japanese people still believe drug users are criminals. So, which method or which way we have to choose for recover or punishment or other methods for drug users? Imprisonment or the treatment in community-based treatment, or the very confusing in Japan.
Okay. Okay. How would you say the justice system here in Japan and the United States is similar?
Similar, so most difficult questions, I think, because I guess there are a lot of things perhaps, but I thought about it, but I couldn't come up with anything. Maybe it's because I'm expert and I only focus on the differences. Maybe there are many things that are similar, but yeah, I don't know.
Since you're the expert, I'll take it that there are not a lot of similarities.
Just differences.
You've written, as we've discussed, you've
Yes.
written extensively on drug court policy, including a paper that I've
Yeah.
looked at, which is what is the problem that problem-solving courts have to solve? What is your views on problem-solving courts?
First of all, I want to thank you for looking into this. Thank you. I've written a paper on what problem solving court should address, and criminal procedure law experts in both the United States and Japan moved some criticism against these courts. For instance, there are concerns about the presumption of innocence, the right to a speedy trial, and the possibility of coercing confessions. From the perspective of traditional criminal procedure law,
Yes?
problem-solving courts might seem like an innovative system that doesn't fully fit the mold. However, as I mentioned earlier, these courts can solve social issues for clients that the traditional courts often cannot. Although problem-solving courts have developed to address the needs of their clients, they constantly face challenges related to criminal procedure law and constitutional concerns. Interestingly, if you look back to the 18th century, there were already ways of resolving social issues outside of the formal court system.
Yes.
Even today, nearly half of all cases are resolved through methods that bypass traditional criminal courts,
Yes.
so they can't be explained solely by criminal procedure law. In short, while some experts point out problems with the Code of Criminal Procedure, about half of the cases are still handled through alternatives to traditional trials. So I thought the problem that the problem-solving courts address isn't just the client's problem, but also the limitation of traditional criminal trials. That's the key point of my paper. In other words, problem-solving courts not only help clients, but also offer solution to the problems within traditional courts. These are points of my paper.
I saw that.
Yeah, you saw that.
And I think it's important that we talk about that because you're talking about this, and I'm not asking you a question.
Just comment.
It's a comment. You're saying that problem-solving courts are solving a larger societal problem than a traditional criminal court would handle. And I happen to agree with that view. And I thought it was interesting that you explained it to me, a practitioner in the United States, in a better way than I thought. So I really appreciated that paper.
Thank you.
You've also written extensively on therapeutic jurisprudence and harm reduction.
Yes.
Can you talk about that, please?
Yeah. Okay. I also conduct research in countries and organizations that have adopted harm reduction policies. For example, I have researched not only USA, but also Canada, Portugal, Netherlands, UK, Spain, Thailand, and Germany on several occasions. For better or worse, therapeutic justice is rooted in the criminal justice system, which means it constantly faces the challenges I mentioned earlier. If clients fail to meet their obligations, they may end up in a criminal trials and possibly face imprisonment. This situation does not imply that we overlook the importance of independence. The ineffectiveness of drug policies based on criminal penalties is well documented, and both the United Nations and the World Health Organization have issued warning against relying on such punitive measures, as they can lead to stigma and prejudice. So, however, there is a debate about whether harm reduction should be applied in all cases. In some instances, therapeutic justice might be more effective. I guess it's like some cases with violence case or other cases. So it's not just about choosing one approach over the other. So I believe it's crucial to distinguish between these methods in the future.
With that, Doctor,
Yep.
I'd like to thank you for having come on Justice Speaks, and we're done.
Yep.
The Justice Speaks podcast is brought to you by the Justice Speakers Institute, LLC, the premier international speakers bureau on justice issues. This podcast is to give you the knowledge and be able to ask the questions on creating justice in your community.